Hello, hello, hello. This is Attorney Mike Grevin coming to you from Chicago as usual. And every time I try to get something done, somebody like Jeremy Schuh goes to court, misbehaves so badly that I have to get on here and discuss it just for my own therapy. I know a lot of you were there. I know a lot of you saw it. I know a lot of you told me about it. Let's do it. It's good.
It's back in session.
Okay. We are back on the record. People versus Jeremy Schuh, case number 18855FH, 19378FH. Record should reflect a bench conference with counsel and probation to talk about possibilities and dismissal of counts in the violation of probation allegations. I did, in that discussion, we talked about what our different perspectives and options are. Both counsel as well as probation were very clear about that.
Oh, yes.
So I think what we're going to do is have Mr. Collis, do you want to highlight for me what's in your motion? I'll have Ms. Blanche response. I've had a chance to review it. I'll rule on the motion, and then we'll proceed with what's next. Okay?
All right. Thank you very much, Your Honor. Your Honor, as I indicated in my motion, it's our position that any probation violations would have to be resolved during the probationary term. Probation in this case would have ended on July 6, 2022. A number of the violations, especially the ones that probation now seeks to add, were after that time and date. And we believe the Vanderpool case supports that proposition that those violations of probations had to be resolved within the term of probation. Now, I appreciate that there are some issues that were from before then, but again, I think those had to be resolved timely, and they were not. As we've indicated in this at the bench, in Mr. Schuh's case, he's already served more than the time on the sentence in jail. So he's not eligible to go back to jail on anything. Consequently, Your Honor, we're asking that the probation violations in this particular case be dismissed pursuant to the Vanderpool case, and if not, release Mr. Schuh out on bond to address these issues, and also to remove the no contact order with Donna Uton, so that this case can be, again, heard for date and time.
All right, Blanche?
Although the maximum jail sentence has been served, the maximum prison sentence hasn't. So there is an eligibility for him to go to prison based off these violations. He has not served the maximum amount of time on probation for a felony, which is 5 years. The Vanderpool case does not even apply in this case, because in Vanderpool, they actually filed the probation violation after probation already expired. This was filed in March, the first violation. And if you looked at People versus Ritter, which is actually the case that is at issue here, it says that probation can tack on probationary charges if the first violation was filed prior to the end of probationary term. His maximum, as I said, is 5 years for probation under a felony. So I believe that we are correct here as far as it stands, and we ask you to deny his motion.
All right, what about if
Okay, so I'm not familiar with the case that they're citing, but so far it's two good attorneys making good arguments. Jessica Blanche has a nice response to the attorney. Stuart Collins, who's got fabulous hair, by the way, just a whole head full of it, does a nice job trying to do something for his client. And here we go.
If I were to deny the motion, what's your response on bond?
Judge, I would like him to stay in based on continued conduct. He has 2 R&Os that he just committed while he was in jail against officers. He continues to violate court orders. In fact, the last time he was here 2 weeks ago, he's swearing on the record. I don't believe he's shown to the court that he can file any rules And in fact, when it comes to the no contact order, I mean, I don't even know why that's being addressed because he continues to contact her while he's in jail. He contacted her yesterday. So, I mean, he keeps violating bond and court orders.
Okay.
They don't say, but probably on the jail phone, which absolutely everybody on the planet gets busted for. But yet they continue.
Agent Benetti, any comment before I make a decision on the motion?
Or I'd leave it to the court.
Okay. I've had an opportunity to review the motion filed by Mr. Collis. I reviewed the response filed by Ms. Blanche. At this time, as far as the motion to discharge the defendant from probation, I do find that the Ritter case is applicable in this matter and that I will deny the motion to discharge at this time. As to the question of relief or modification of his bond to a PR, I am going to also acknowledge that my own view of Mr. Schuh on the record at the last hearing was sufficient for me to have concern enough that I'm not sure that PR is the right response here. So
Actually, I'm not sure if he's in jail or not.
the other
at the
piece
moment.
of this is that what we did discuss in the bench conference was the concept that Mr. Schuh, and this was placed on the record before we went into the bench conference, I think, that Mr. Schuh potentially might plead guilty to technical violations and have the court move to sentence, but that he was not willing to plead guilty to any non-technical violations. And so I am assuming that is your position, Mr. Collis, on behalf of your client. So I think what we need to do is set a violation of probation hearing with all possible charges. And then if he's found not guilty, then he's found not guilty and we're done here. If he's found guilty only of technical violations, I think we are likely done here as well, because I think we know what the outcome there is. If he is found guilty of applicable non-technical violations, then we would theoretically move to some sort of sentence on that, and I would entertain both probation as well as the prosecutors and the defense's input into that before we were to proceed. So I think that's where we are. So, Mr. Schuh, you are welcome to ask a question, but I just want you to know that we're on the record and you know that. And so what is it? What can I do for you?
My question, sir, is one, like I spoke to Mr. Collis, I do have, and Ms. Benetti is well aware, I do have mental health issues. My outburst is I'm on medication for it. I apologize. I'm trying to deal with it as best as I can. I'm on medication. I just spoke to mental health today about staying medicated once I get out. I'm willing to deal with whatever the court needs. If it's tethered, if it's anything the court deems fit, I'm willing to do. Even extension of probation, whatever is necessary, just to get this resolved and to get out to my family and to my fiance who needs me very badly.
Okay, well, but the problem is, and this is sort of, I don't want to gloss this over, is that we're in a situation where you are charged with violations of probation that involve non-technical violations. And if you were found guilty of those, like if they weren't dismissed and the people can proceed and probation can proceed on those, and you're found guilty of them, you theoretically could be sentenced to prison. So, I mean, that's on the table. I'm not saying that's what's going to happen, but I'm guessing that at this time you are not willing to plead guilty to non-technical violations, which could result in your imprisonment. Is that accurate?
I am willing to plead guilty to anything to resolve this. And Ms. Benetti's recommendation was that probation be extended. I would ask that recommendation.
Let me interrupt you for a moment. The prosecutor wants to send you to prison. While Ms. Benetti's recommendation is her recommendation, Ms. Blanche wants to send you to prison. And that's not something you're willing to do. And that's why we want to have memorandums before the judge.
So I guess that's why I'm not sure you really want to plead guilty today, because the request of the people, and in fact, the recommendation of probation might be to sentence you to prison. So, Agent Benetti may have spoken with you, but, again, there are recommendations. I'm not sure what she'll do. She may not, but I could, and the prosecutor's office could ask to send you to prison. So I got to consider all these things. That's my job.
So there's the crux of the problem right there. He thinks based on his conversation with the probation officer, who, by the way, didn't give him this impression, just mentioned what her recommendation might be. That he thinks that if he pleads guilty to technical violations, then all this goes away and he can walk out of jail. But the problem is that hasn't been offered to him, and he just can't accept that.
I'm not taking it lightly, and I'm also not saying I will send you to prison, but you need to know that it's possible. So I don't know that you really should or want to plead guilty to these violations. I think you're entitled to a hearing on them. So
my thing, Your Honor, is I have been in jail, and may I speak? I'm sorry.
Sure.
Okay. My thing, Your Honor, is
Okay, he has a moment here, like just that is a bit of it, where he's so civilized that I'm thinking maybe he's really changed, maybe he's really learned a lesson.
is the court, or not the court, but I'm sorry, I apologize. The Miss Blanche's recommendation and Mrs. Blanche's argument for People versus Vanderpool is the same argument that the dissent in Vanderpool, the but the Michigan Supreme Court made. It's the same dissent that failed to get a majority vote in Vanderpool. She also argued, I read the motion, she also argued the Michigan Court of Appeals Vanderpool case that was actually overruled by the Michigan Supreme Court, which that argument failed as well. She's arguing a Michigan Court of Appeals case to overrule a Michigan Supreme Court case, which is a higher court, clearly. Your Honor, Mrs. Blanche was the same prosecutor that has retaliatorily and maliciously prosecuted me for a domestic violence and a witness intimidation case that she knew had no probable cause. Mrs. Blanche.
So, Mr. Schuh, what we can do is this. You just have to know, because I'm kind of in the same boat here. We're all trying to do our jobs. So when people throw out the term malicious prosecution or some sort of retaliation, I promise you, Ms. Blanche is not seeking to maliciously prosecute you. She gets hundreds and hundreds of warrants crossing her desk every month, and she reviews all of them in the same way. It's not personal. It's what is on the paper in front of her. I get the same kinds of things too. And so as we are all trying to do our jobs here, there is a process. And so we're not going to get into what Ms. Blanche did or what Agent Benetti said. What is on the table is that if you want to plead guilty to all of the technical and non-technical violations that are pending before you that are not going to be dismissed by probation, we can do that today. And if you plead guilty to those violations, I will set a sentencing date, and I will consider everything from releasing you free and clear to sentencing you to prison. So that's the span here. And it's not as simple as Agent Benetti's recommending discharge from probation or extending probation. It's not that simple. So your choice today is to either plead guilty or to plead not guilty, or you've already pled not guilty, and we'll set a hearing. Just so that you know, frame of reference, we will have the hearing either on the morning of October 5th, October 12th, or October 19th. So whether I let you out or keep you in, we're not talking about another 6 months wait here. I'm going to give you a Wednesday morning in the next 3 weeks to have this hearing, and we'll be done with it. We'll make our decision and we'll be done. So that's kind of what's on the table today. I got a huge docket, and I probably can't take much more time on this. So I'm happy to have you respond briefly, but just know that it's either going to be you're pleading guilty to everything that is not dismissed, technical and non-technical, or you're going to have one hearing on one of those 3 days. So go ahead.
The guilty plea, what is going to be, if I pled guilty, what would be the next step?
I would set a sentencing date for one of those, for a week or two from now, and I would sentence you on your guilty plea. And that would be anywhere from releasing you because you've already served a year, or I would be potentially sending you to prison.
Either way, Mr. Schuh, you're waiting 2 to 3 weeks.
I completely understand. I do have one question real quick before, and I understand,
sure
Your Honor, you have time. However, I've been spending in here, the time that I've been spending in here, we have Washtenaw County is in a hiring crisis where they can't even get officers to work. Their officers are working 16 to 18 hours a day, having a heart attack in front of.
And guess what? Jeremy's got the solution. And that solution is let him out of jail.
Because they're so overworked but yet I've been in here for since June 18th for a simple argument with my girlfriend inside of her house. I don't understand this. This is not justice.
So is there a question in there, Mr. Schuh? You said you had one more quick question.
I'm sorry, sir. The question is why can't we just plead to technical violations and do whatever needs to be done and have this resolved in a just manner? That's the only question that I'm asking.
Well, I fully endorse, sir, that's your position. But there are other people who have differing positions on this. So that, I got my job, frankly, if we want to talk about everybody's role in this, is my job is to listen to everybody and make a decision. So I can't just take your position that this is somehow an injustice and let you out. I mean, because frankly, all of your peers and contemporaries who are going to appear before me this afternoon are going to say the same thing. They shouldn't be in there. They should be out. I get that. But we're talking about whether you're going to plead guilty to everything that's on the table or not. And so October 5, 12, or 19 at 9:30 a.m. are going to be those hearing dates. It's going to be in person. So we're going to have you transported down here and we're going to have a hearing.
October 5 is Yom Kippur, so I can't do that. So the 12th or the 19th, Your Honor?
And if there are necessary witnesses that have to appear by Zoom, we can probably accommodate that. But I do want the attorneys and I want the defendant and any witnesses that are available to appear in person. Okay?
The 12th would be fine, Your Honor, or the 19th.
How about you, Ms. Blanche? 9:30 on the 12th, would that work?
That works, Your Honor.
Okay, so Mr. Schuh, you understand that I'm not going to take your guilty plea today. It may be that we work out some sort of plea on that morning. It's possible.
Your Honor,
or maybe you're found not guilty. I don't know.
I'm sorry, Your Honor. I thought it was going to be in the afternoon. If it's going to be the morning, I can't do the 12th, but I can do the 19th.
Okay.
I've been here for
How about the 19th?
2 months for something I didn't do, sir. And you're saying that you want to adjourn it longer. I don't understand. I would ask for the 5th. In all honesty, yes, I understand it's Yom Kippur. I'm also of the Jewish faith. I'm willing to do it on the 5th. Justice is supposed to be done per the Jewish faith on any day.
Okay, well, I'm going to be here on the 5th, but your attorney cannot. So that's the hard part for me.
I mean, that's pretty bad. Like, I get it, you're in jail, but you're in jail of your own making, and now he's dumping. He just completely throws his attorney under the bus, who, in my estimation, did a fine job of arguing on his behalf. He doesn't have a lot of good facts, and he tried to bring a case in that I don't think is applicable, although I don't know. However, that's probably the best available, and he's doing a nice job advocating for him. And now he's just dumping all over him because he doesn't want the continuance to be longer because of Yom Kippur. Oh, good Lord.
So the 19th then, Your Honor?
Ms. Blanche, is that all right with you?
That works, Judge.
All right. Hearing set on October 19th at 9:30 a.m. It will be in person, at least for the defendant and the attorneys and any available witnesses. If there is a need to have a witness appear by Zoom, I want notice of that before the hearing and time to address it if there's a response to that. As to the motion for personal recognizance, I'm going to deny that at this time. Remand the defendant pending the hearing. Thank you.
Thank you very much, Your Honor.
This is injustice, sir. I would ask that you be recused. I think you're biased.
Mr. Schuh, you're not helping yourself. Please be quiet. We'll deal with this later, okay? All right.
I've been suing probation department and I sued Washington County. I would ask, I am not safe in the county jail. I would ask, due to my current lawsuit.
Talking. You're not helping yourself.
You're not helping me. You're not helping me. You just asked for another month. You're not helping me. I've been in here for over 2 months or over 4 months for nothing.
Your Honor, if you can
argument. You're not helping me. How are you helping me? Are you retaliating? Are you conspiring with the court and the prosecutor to keep me in here?
Look at that smile on Jessica Blanche's face. They were just going at it. They were fighting, and they were into their arguments, which is good and appropriate and professional. But they were just knocking heads 5 minutes earlier, and he was doing it on his client's behalf. And Jessica Blanche is like, "What? You're accusing your attorney of conspiring with me now? That's good."
Something I didn't do with the potential of sending me to prison for something I didn't do when I got 2 cases already beat. For, again, something I didn't do. I don't understand it, Mr. Collins. I don't understand how this is justice.
Okay.
Washington County can't even afford to hire.
Thank you, Your Honor.
Number 29, People versus Jesse Stamper, 22475 FH.
Jessica Blanche, yeah, people.
No.
You remember that mute thing, Ms. Blanche, from the last time, right?
I
Dirty
didn't
little secret.
I didn't even ask you.
Right? Well, we tried. Dirty little secret. You can't do it. All right.
Well, there you have it. That was just too good. I think what the judge is referring to is that you can mute them, but then they can unmute themselves on Zoom. So I think it was the judge or his clerk or somebody who finally hit Jeremy with the mute, which, by the way, is doing him a favor because all he's doing is contempt of court, making himself look worse in front of the judge who's going to make the decision. The next determination of when he gets to leave jail. And I mean that's why I called this incorrigible on the thumbnail. I mean, I've seen so many videos of Jeremy Schuh, and they all end the same way. And this time, I truly did. I saw in the chat. I truly did get suckered for a second. I'm like, I doubt it, but maybe he's reformed. Maybe because he was a lot more polite and he was going along and he was apologizing and everything. And then, he starts right in. He's going to sue everybody. His attorney's conspiring with the prosecutor. The judge is prejudiced. Yeah. The whole rant, the whole routine. And I thought, okay, there we go. There's Jeremy. I think that, this will go on for decades. Honestly, I don't think he can close his mouth for an extended, long enough period of time to ever leave jail. That's my current feeling. At least he hasn't figured it out in the first 23 attempts I've witnessed. So I don't know. Unless someone can get through to him, and I have my doubts. All right, just a quick one. Thank you all for coming out. I really appreciate it. I didn't mean to do that, but y'all sent it to me and it was good. So I just did it real fast. I will see you soon.